speakers to share insights from their various jurisdictions on the issue of privacy and data protection, some of them from a broad perspective and others from a very narrow perspective. Without waste of time, we'll start the presentations immediately, but I'll just briefly want to tell the presenters that you have 15 minutes presentation, you have 15 minutes for the presentation. When it's 12 minutes or 13 minutes, I will alert you that you need to round up. Participants are free to ask questions using the chat function. In your responses to questions, I'll urge the presenters to please be as brief as possible so as to accommodate a lot of other participants and so as to make it a bit, so as to make this session very robust. The first presenter is Professor Ewan Sutherland. I hope I pronounced it properly. Prof. Ewan is an independent telecommunication policy analyst. He has undertaken assignments in Asia, Southern Africa, and Europe for governments, ITU, and the OECD. He was the executive director of the International Telecommunication User Group, INTUG, based in Brussels between 1999 and 2005. He spent 15 years as an academic, later as a dean at the University of Wales. He has taught at the University of Wolverhampton, Westminster, Stirling, and Wales, plus semesters as visiting faculty at Georgetown University, Washington, D.C., and GSTIT, Addis Ababa. He has also associated in various capacities with the Link Center at the University of Witwatersrand for 2 decades, serving as visiting professor from 2013 to 2019. Prof. Sutherland is going to be making a presentation on the governance of data protection in South Africa. Prof. Sutherland, you have 15 minutes for this very interesting presentation. Thank you very much.
Thank you. Let's see if we can. Is that working correctly?
Yeah, I think it's okay.
Right. My background, as was said, I've been doing work at Link Center for 20 years. My background is partly in telecommunications policy, but I go way back on data protection to some of the original work in the United Kingdom and the OECD in the late 70s, early 1980s. This is in parallel, in a sense, with work I've done on telecommunications policy and a case study published a couple of years ago now on the governance of cybersecurity in South Africa. What I want to do is very quickly go through all of that. The interest here is not in the data protection directly, but in its governance. That means we have to consider the roles of Parliament, of the courts, of independent regulator, of civil society. It means we have to look at different levels. It means we have to look at the 2 principal pieces of legislation and see what we can learn from the South African case study. Multi-level governance is a fairly well-established concept. Some academics don't like it. They claim it's too normative rather than an analytical framework, but it helps us to try to unpick the different levels. So the activities at the global level, continental, regional, and the point I made yesterday is there is no agency at the global level. So although there are agencies dealing with cybercrime and with various other bits of this area, there isn't a global legal instrument, there isn't a global treaty, there isn't a global agency. Continental treaty, as has been said, has not been signed by enough countries and therefore is not legally binding. We'll come back to South Africa's position on all of those in a moment. There's then work within SADC for the Southern Africa region, but that's not legally binding. It's quite interesting, but some of that again points you back to external influences. So that may be coming from some projects funded by the European Union, which may not themselves reflect local requirements. Data protection involves work at national level, at provincial level, at municipal level, because it is not simply a question of having the legal framework in place. It requires government to store data securely, so it has to have robust cybersecurity, it has to observe data protection, and that then goes down to different levels, to the provincial level, to the municipal level. It's also very closely linked to cybersecurity because if you don't hold the data securely, then you start to run into some really quite serious problems. One of my colleagues, who shall remain nameless, is complaining at the moment. It's somewhat embarrassing that his university is under attack and that they have lost access to some of the computer systems because of what I think is a ransomware attack on the university. So the governance has to reach out. It has to reach universities, it has to reach schools, it has to reach churches and charities in order to get them to observe good data protection and good cybersecurity. And that makes it very, very difficult. Big part of the problem is to do with trans-border data flows. Economies of scale mean that it makes sense to have large data centers. Now that issue goes back to what, the late 1950s. But economies of scale also favor social networks. And that means that people in South Africa are typically using social networks which may be based in the United States of America or maybe based in China. It's much, much less likely they're using local systems. So that raises questions of data flows across borders and differences in legal and regulatory regimes. You have to strike a difficult balance. How much data belongs to the individual, how much to the corporation? Where does the balance struck again between the individual and national security? And that resulted in these international legal instruments, and as is well known, taken up in the European Commission. South Africa had a right to privacy going way back in its case law in the 1950s. So in the common law in South Africa, it was clear that there was some measure or recognition of privacy, and that remains. The 1996 Constitution gave a number of rights, including a right to human dignity and a right to privacy, and that's set out fairly clearly. Interestingly, that is presently being tested in the South African Constitutional Court by a review of the regulation of the Interception of Communications Act. Now, the RICA Act raises difficult problems because it allows interception by the state. It also requires registration of every single SIM card in the country. And those all present problems. They also, immediately you think about that, present some quite serious challenges in data protection. A number of African countries, not South Africa yet, are requiring biometric details to be held, which makes the databases potentially very, very sensitive. So the right to privacy is being tested against statutes, it's being tested against individual actions, and that is really quite slow, but it is working. South Africa has not been a good international player. It signed the Universal Declaration of Human Rights, but then everybody did. Catch is it's unenforceable. Yes, there are some reports, but it's not in any meaningful way enforceable. It signed and ratified the African Charter on the Rights and Welfare of the Child, and as was being pointed out this morning, that's quite important, and that represents an interesting way to get international enforcement. South Africa did not sign and has not ratified the African Union Convention on Cybersecurity. Somebody challenged the minister on that recently. There's really no answer why they didn't do it. it didn't sign the European Council Convention on Data Processing. It oddly enough signed the Budapest Convention on Cybercrime, but then proceeded not to ratify it. So it's not really looked to international instruments as a way of doing anything. Back in 1999, two things happened. One I'll come to in a moment, which is to do with an act most of you, I think, will be familiar with, the POPIA. It also resulted in much, much faster. Now, the contrast between these two is very difficult to understand. One piece of legislation has taken 20 years, and the other passed into law within 3 years. It was a bundle of things to support electronic commerce. It borrowed globally, but it was never implemented. So it's an interesting instance where somebody who I think we would describe as a policy entrepreneur saw that things were happening globally, brought them into South Africa, wrote them into a green paper, got cabinet to agree that the green paper should be made into a law, but didn't work. So it was supposed to have cyber inspectors who were to help the police to interrogate databases. It was supposed to create a statutory basis for principles of data protection, didn't work. It supposedly protected critical databases, didn't work. There were no cyber inspectors appointed, no critical databases were ever designated, and that's now being dismantled, with sections have been repealed by POPIA and will be repealed with the Cybercrimes Bill. It's really very hard to explain why it took 2 decades to get proper data protection legislation, given that there's nothing intellectually very complicated about data protection. It's easy enough to borrow the models from other places. It's not that difficult to customize it for South African law. European model fits across a whole range of European countries. South African law isn't that different from a number of European countries, so it could have been done. It was easy enough to do this, but somehow it took. There wasn't the demand, there wasn't the pressure, there didn't seem to be the security incidents, there didn't seem to be people complaining about the problems, and so it drags on and it drags on and it drags on. And as we've heard earlier today, someone was commenting that the budgetary question stands. It's not clear how much money will ever be made available for the regulator. It's not clear that it will be effective. And the catch with that is that you don't have in place the guidance notes for business, the guidance notes for voluntary organizations, the beginnings of the reports of the data breaches, which start to tell you what's the scale of the problem. Until you start to get those reports coming in, you don't really have a sense of how serious a problem this is. Effectively, with businesses in particular, you don't get them convinced until you start threatening putting big fines on companies or putting directors in jail. So the 2 decades of delay are for no very good reason. It's not, there isn't something special in there when you get to the legislation at the end, which says this is South Africa. There just isn't a sense of a culture of data protection in place. And there are suspiciously few reports of data breaches. Not clear that it's being applied to social media platforms. Data seems to be being taken out of countries, South Africa, as with other African countries, to US and to China. Poorer customers, and this is really quite a problem, are being pushed towards using cheaper and using free services, basics, Facebook basics, what have you. And they're free because they're providing their data. A good Marxist will tell you that it's not free, that you're performing acts of labor for the benefit of the Chinese or the American social network operator. There have not yet been legal tests of the constitutionality of exemptions for national security, defence, public safety, nor this rather peculiar South African exemption where data processed for cabinet. One has visions of, Mr. Ramaphosa sitting somewhere doing something with the database, which is exempt from data protection law, which sounds very odd. And it's doubtful, because it's taken so long, that you could imagine a review taking place before maybe 2025, possibly longer. And that in itself, given what we know about the advancing technology, presents a real problem. So the obligation to have a right to privacy is in the Constitution. It's a right. ECTA was a bundling together of legislation in a way which is really unsuccessful. It failed to implement, but criticism here of Parliament, there wasn't post-legislative scrutiny. Parliament never dragged the people in to say what went wrong, what lessons do we learn from this. Then you have this very slow creation of the data protection regime, and you have poor coordination between the ministry and the Foreign Affairs Ministry, DIRCO, to deal with the international instruments. So we don't yet have a clear picture of the patterns of data breaches in South Africa. We don't have a culture of protecting personal data. And President Ramaphosa goes on and on about fourth industrial revolution, but that implies rapidity, it implies deploying the latest technology, getting things done, and we don't see it here. We don't see a sign of revolution in government to get this done. And that is me, and I'm within time.
Absolutely, you are within time. Thank you very much for the very brief and very brief and very timely presentation. Okay, so I will go back to the participants. Is there any question? I can't really find any question here. I can only see a comment. Okay, I can see a question. Prof, are you with me?
Yeah.
Okay, so there's a question from Tokwe. The question goes, will common law protect private facts that are utilized in criminal investigations, but which are neither protected by the POPIA or the RICA in criminal justice?
I'd be surprised if that was the case, but I'm not a common law expert, so I want to defer. I come more from the regulation and governance side of the shop, but I suspect not.
Okay, there is also another comment. I think it's more of a comment. It's from Gabriela. She says, those cabinet exclusions are hangovers from the PAPI and have particular political basis in some progressive versus non-progressive government debate. I think this is just a comment. But before other questions come in, I have my own question. Probably I'll just send in when one or two other questions come in. My question goes thus, given the nature of data protection instruments in Africa or in South Africa, do you think the operation of the POPIA at the federal level, it's more of an operation in the federal, do you think the structure in which the POPIA is designed, do you think it's designed will enable it to trickle down to the provincial levels and so on? Because we have this information regulator that is basically operating probably in the capital cities and so on. What innovative means do you think can be put in place to ensure that the implementation of the act trickles to the provincial level and trickles to the grassroots level?
The big challenge is to get down to small organizations who might be holding the data. And that's where things like an information regulator can produce guidance notes to say, not necessarily, to take the act and turn it into something that somebody who has the database for the local school or a local choir or a golf club or whatever can understand and hold the data securely and safely. So it's an educational role. There's at a higher level, there's a question of does my university, WITS, educate its engineers in data protection? So it's how do you get that into the formal education, and how do you get guidance notes out? How do you get support out so that everybody understands that they should be holding the data correctly, and to have the right software tools, the cybersecurity tools, to make sure that somebody isn't stealing it?
Okay, thank you very much. I have another question. Somebody is asking on the remedies or the remedies that are available in the Protection of Personal Information Act. I think the question basically is looking at if you really believe the remedies are adequate. Then I also have another question. Probably you take them together. The question is from Asefa. It says, privacy in the era of COVID era, where contact tracing is the norm, can the right to privacy still be protected and enforced? Probably you just take these issues generally.
Yeah, well, the COVID is raising funds.
Hello, Prof. Hello. I think we have missed Prof. I think we have missed Prof. Pending when he returns, probably we'll take another presenter. Okay. When he returns, we'll take another presenter. But before then, any other questions that are going to be directed at him should please be typed on the chat box. We're going to ensure that he answers them when he returns. Now, my next speaker is Mr. Collins C. Ajibo. Mr. Collins, are you here? Oh, Dr. Collins C. Ajibo, I'm sorry. Are you here, Dr. Collins? Dr. Collins?
I have been muted by...
Okay. So Dr. Collins is going to be presenting, or the title of Dr. Collins' presentation is Data Protection in Nigeria, Progress, Drawback, and Options for the Future. Dr. Collins is a senior lecturer at the University of Nigeria, Enugu, Nigeria, and the head of the Department of Property Law in that university. He had his master's and his PhD from the University of Manchester in the United Kingdom. He has also published very widely in international and national peer-reviewed journals in broad areas ranging from international corporate and finance law, international dispute settlement, and international economic law. So Dr. Collins, we have 15 minutes to tell us about data protection in Nigeria. Over to you.
Thank you, everyone. Thank you, Lukman. It's a pleasure to present in this virtual conference, if you like. Right, basically, I shall be presenting on data protection in Nigeria, progress, drawbacks, and options for the future. Now, basically, until 2019, data protection law in Nigeria was regulated basically by Section 37 of 99 Constitution of Nigeria, Federal Republic of Nigeria, as amended. But in 2019, there was a data protection regulation, which was made applicable to Nigeria and various institutions and entities and persons, if you like to. Now, again, before 2019, it is clear that there was an AU Convention on Cybersecurity and Personal Data Protection, 2014. But Nigeria neither signed it nor ratified it. Equally, there was ECOWAS Personal Data Protection 2010, but it was not really as well. It was not really well known in Nigeria as it should be, apart from practitioners in the field. Now, apart from the 2019 data protection regulation, there is currently a bill for an act on data protection in Nigeria. The bill is still under consideration. So basically, apart from the 2019 regulation, a law from the National Assembly is still under consideration. Now, again, it is envisaged in a manner characteristic of Nigerian environment that even if the bill eventually passes into law, the possibility of disobedience of rulings arising from that bill cannot be totally dismissed. Right. I just highlighted the problems that exist, that militate against data protections in Nigeria. And I now move on to research questions which underpin this presentation. And in the research question, I pointed out two main questions here, and they are the following. What are the shortcomings of the existing legal and regulatory frameworks for privacy and data protection in Nigeria vis-a-vis the international best practices? And how can the protection of privacy and data be effectively implemented for the benefit of all stakeholders consistent with global best practices? Now, if you refer your mind to the problems I highlighted above, you see they are also embedded in part of, they are also embedded in what these questions are meant to address. Now, the methodology I use, or the presentation I use basically, is doctrinal by examining the existing law and policy in respect of data protection in Nigeria and trying to find a way to solve a problem, if any, to make sure that there is adequate and effective protection of data in Nigeria. Now, approaches to data protection. Now, looking at the manner in which the data protection environmental regime in Nigeria is being constructed, that is based on regulation and the current bill being under consideration, it can be argued that Nigeria chose a government regulation approach. Okay, and this is in contradistinction to an alternative approach, which is a self-regulatory approach or self-regulation approach, if you like, where upon data protection is based on evolution of norms and industry best practices of good faith compliance, in which companies and entities are expected to abide by data protection, even though there could be no parliament legislation or enactment from the parliament. So Nigeria basically is following a government regulatory approach or government regulation approach on the basis of the regulation of 2019 and the current law under the current bill under consideration. Now, looking at the 2019 regulation and the current bill under consideration, we can glean out certain objectives of data protection in Nigeria. And they include the following. Number one, to establish and provide an efficient regulatory framework for the protection of personal data in Nigeria. And secondly, the protection of the rights of data subjects and the use of data. And third, to enforce responsibilities of data controllers and processors. And fourth, to safeguard from the fundamental rights and freedom under the Constitution, particularly Section 37 and others related therewith. And fourth, or finally, the last but not the least anyway, to maintain competitive business environment that is just and equitable in line with the global best practices. So these are the objectives that underline data protection in Nigeria on the basis of the existing framework, that is the 2019 regulation and the current bill under consideration. Now we move to the principles of data protection as can be seen in the existing frameworks. Now, looking at the 2019 regulation and the current bill before under consideration, we can see, it can be seen that the principles of data protection, or let me put it this way, the global principles of data protection are complied with by those two instruments. And basically, it was the principles seen in those two instruments seem to be modeled after the 2016 EU General Data Protection Regulation. Specifically, there is a requirement for lawfulness, fairness, and transparency in processing of data. That's the first one. And secondly, you have people's limitation, which is that data processing should be specific, explicit, and be processed in accordance with legitimate purposes. And the third one is data minimization, which is a requirement that data processing should be relevant and limited to what is necessary in relation to the purpose for which the data is being processed. And you have another one, which is a storage, which is a data accuracy, which is a requirement that there should be accurate, data processing should be accurate, and it should be regularly kept up to date. And you have also storage limitation, in the sense that data processing, the data stored should not be indefinitely. It should be deleted once the purpose for which it was processed is timed out, if you like. And there's also a requirement of integrity and confidentiality in the processing of data. And the last but not the least is the requirements of accountability in the processing of data. As I pointed out initially under this slide, the principles of data protection as evidenced in these instruments in Nigeria are compliant with global best practice, particularly the 2016 EU General Data Protection Regulation. Now we'll move to specific provisions of the data protection instruments in Nigeria.
I'm sorry, Dr. Collins, can you just hold on a bit? Do you have a PowerPoint that you're presenting with? Because absolutely. I don't think we can see the PowerPoint. I think probably you need to check your settings. We cannot see the PowerPoint.
You can see it.
So please, I think you can see it.
Okay, so
I think you need to share your screen.
No, I sent it before now. That was yesterday.
No, but you need to share your screen from that end.
Okay, no problem. Let's see what I can do. But what about my time? Because of you have the cutting, you just cut in.
Yeah, if you can quickly just do that.
Has the time stopped now?
If you can quickly do that, is it possible you quickly do that in 1 minute? If you can't, you just go on.
I'm not sure. I'm not sure because I sent it before. I thought they operated from. Yeah, I'm sorry about that.
No. You're supposed to.
So should I go on then?
Yes, you just go on with your presentation. Thank you.
So I sent it 2 days about yesterday. I sent it.
You can just go on with your presentation.
Okay.
And go on.
It's all right. So we have specific provisions from the instruments in Nigeria, and we have the first one, the lawfulness of personal data processing. That is data, as I just consistent with what was pointed at before. The processing should be lawful and in accordance with the law, and the concept of data subjects and transparency of personal data processing. This also entails that if a data processing is based on the concept of data subjects, it should be conducted. The processing should be conducted in accordance with that consent, except as may be authorized by the law. Now we also have the rights of data subjects. This requirement simply means that if there is a data breach, the data subject should be made aware of it. Moreover, there are also other requirements like the right of access to information relating to details of data processing. There is also other related rights, such as the right not to be subjected to automated decision-making except as authorized by the law. Right to rectification, erasure, and restitution if data is inaccurate, false, or unlawfully processed. And there's also the right to judicial remedy if the provisions of the Act is violated. All these rights are attributed to the data subjects under the current instruments in Nigeria. Now, we also have provisions regulating the processing of sensitive data. And now, sensitive data is regarded as data that relates to, let's say, ethnic, racial, or ethnic identities, political opinions, and philosophical views, data related to health, information related to health of the data subject, among other requirements. And also, the provisions also require the data controllers and processors and this include, for instance, the data controller must be data controller must be data controller must take all necessary measures to comply with the requirements of the Act or the instruments. And there is also vicarious liability, assuming there is an agent representing the data controller violates the provisions of the Act. And also alternative other duties relating to data processors, and they are wide, and I only mention a few of them here. And they include a process include a personal data on behalf of if a data is processed based on written instruction of the data controller, then it must be processed in accordance with that instructions. And there is also a requirement that the data processor should not engage another data processor without the prior written authorization of data controller. There are other requirements which are meant to protect the data subjects. Now, you also have the provision relating to data location and security. Now, in respect of a location of data, the Act does not require that the processing should be conducted in Nigeria. But as I said before, in respect of a bill under consideration, there could be alteration in the future, in which case maybe such a requirement might be, incorporated into the Act, particularly if the processor is domiciled outside the country, that is staying outside the country. But basically, in respect of data location and security, the requirement is that there should be security of data processing. Okay. So now again, there are also exceptions to these provisions, particularly there are public interest exceptions. Now, for instance,
Dr. Collins, be preparing to round up, please.
No problem. There's also public interest exceptions, including public safety for tax purposes, security, and fighting of crime, and the rest of them. And the acts also, the instruments also provide for offenses, penalties, and enforcement. Forms of penalties for breach include compensation, fine, forfeiture, restitution, and imprisonment. And we have findings and recommendations here. And the findings include this following: the instruments comply with the global best practices, but they are likely to be enforcement constraints consistent with the Nigerian peculiar environment. And there could also be a problem of disobedience of court and administrative rulings, which may affect data protection in Nigeria. And there should be modalities for robust enforcement of breaches. It should be mandatory in line with global best practices. Our recommendation here is that there should be massive sensitization of the masses. I'm talking of Nigeria, and the compliance should be based on good faith. And in conclusion, It is stated here that authoritative verdicts on the efficacy of enforcement of data protection in Nigeria will have to be made in the future when compliance is monitored, the provisions are tested in courts, data collected and analyzed, and conclusions drawn. Thank you.
Thank you very much, Dr. Ajibo, for this very incisive discussion or this very incisive overview on the state of data protection in Nigeria. You have taken us through the development of data privacy, data protection, right from the constitutional right to privacy. You have given us the Nigerian approach, emphasizing the fact that we have a governmental approach in Nigeria, a state approach in Nigeria. You have also mentioned the fact that the current instrument on data protection is the Nigerian Data Protection Regulation. You have mentioned the rights contained in that document. You have mentioned the principles and explained the principles contained in that document. And you have spoken about the duties of the data controller as contained in the document. I don't know. I'll just check if there are any questions for you. But before I get to that, I would just like to ask you briefly that what, in your opinion, do you think is the reason why the Nigerian government decided to adopt a regulation rather than an act? I know you mentioned the fact that there is a bill already in line. Considering the fact that there have been previous initiatives, there have been previous bills on data protection, why do you think the option of a regulation was a better option for Nigeria, and how effective do you think the regulation is in the protection of personal information in Nigeria currently? So please, you just try to attend to this question while I check if you have other questions.
Yes, no problem. Thank you for the question. Well, I will start off by saying that whatever I'm saying is academic. It's just an academic opinion, if you like, because I'm not working in government agency. I'm working in my own academic field. So it's an opinion, if you like. Right. Having said that, I think that it will be, how will I put it? It will not be completely correct to state that Nigeria preferred regulation to an enactment of National Assembly, given the fact that currently there is already a bill which, if enacted, will supersede, if you like, the regulation applicable currently. Again, secondly, I think that maybe the Nigerian government, successive Nigerian governments, didn't consider the issue of data protection important. And that is why they had to delay to date. And moreover, I reckon when you mentioned that you are from Nigeria, and I also read some of your works, I know. So I also think that apart from practitioners, constitutional law scholars and practitioners in privacy law and data law, most Nigerians appear not to be so, concerned about data issue, except when it affects their businesses or their person. That is when you see that kind of concern. So on the basis of this, I think that maybe that's part of the reasons why government delayed to date. I don't know whether I've answered your question, but if I have not, you can remind me.
No, that's okay. So thank you very much, Dr. Ajibo, for this incisive presentation. I will come back to you. I can see another question which I would like all the other presenters to answer based on their individual jurisdiction. But before then, I would like us to move on to the next presenter, who is Mr. Senwelo Modise. I'm sorry if I have pronounced the name, if I have not pronounced the name correctly. So Mr. Modise is a practicing attorney based in Botswana, and is proficient in the areas of privacy, data protection, cyber law, telecommunication law, electronic transaction law, and digital forensics. He presented at the African Cybercrime Conference in 2019, the Botswana Mobile Internet Summit of 2019, and the Tech Hive Advisory Knowledge Series on COVID-19 and data protection in 2020. Mr. Modise's presentation is going to be on exploring the privacy and data protection concerns of digital forensic investigation in the context of Botswana. So, Mr. Modise, You have 15 minutes and your time starts now. Thank you very much.
Thank you very much. Just a little correction. It's Miss Mudise.
I'm very sorry for that.
Yes, it's okay. I'll just try to share my screen now. Are you able to see it? Are you able to see my
coming on? Yeah, we can see it now. Yes.
Okay. I'm going to be presenting on the privacy and data protection concerns of digital forensic investigations in the context of Botswana. I've already been introduced. It was quite a difficult presentation to pack into 15 minutes, but I'm grateful that this conversation is happening in Africa and that going forward, these issues are coming to the fore and are being discussed. My presentation will touch on the salient terms in respect of the presentation, and the salient keywords here are privacy, data protection, and digital forensics. It will also touch on what concerns are there arising from digital forensics in relation to privacy and data protection. I'll also touch on Botswana's position, the legal framework for forensics, and to ascertain whether there is any adequate safeguards for privacy and data protection. I will also look at the continental outlook. Privacy and data protection, these are interrelated concepts. Privacy is a right an individual has, and the exact nature and the extent of the protection under the right to privacy has evolved over time. This is to say that once upon a time, privacy was only concerned with the privacy of the home or a privacy of someone's premises, but it has since evolved to now include personal information or personal data. And then data protection is a legal mechanism for ensuring privacy of individuals as it relates to their personal data. Now, in Botswana, we have a right to privacy, and we also have a Data Protection Act. The right to privacy is outlined under Section 9 of the Constitution. And Section 9 provides that, except with his or her own consent, no person shall be subjected to the search of his or her person, or his or her property, or the entry by others on his or her premises. On the Constitution, it just says that much. It does not extend to personal privacy, but case law has since postulated that it also extends to personal privacy. The right to privacy also exists under common law. A violation of this right may happen in respect of intrusion upon an individual's personal affairs without permission or justification, and or in respect of disclosure of an individual's personal information without permission. With the Data Protection Act, it is almost the same as any data protection law around the world. It regulates the processing of personal data, and in so doing, protects the individual's right to privacy as it relates to information that identifies the individual directly or indirectly. It establishes a supervisory authority and also outlines sanctions for processing personal data in contravention of the Act. The Act has been passed, but is yet to be implemented. It is yet to commence. Therefore, as it is, the privacy protections in Botswana are under the Constitution and under common law. And this presentation will assess whether those safeguards, the common law position and the constitution, whether in respect of digital forensics, they provide adequate safeguards. Digital forensics and its objectives. Digital forensics is the science of identifying, analyzing, preserving, documenting, and presenting evidence and information from digital and electronic devices. We are in the digital era and we use electronic devices everywhere in our lives. They are now part of our lives. And to extract evidence from those devices that we use on a daily basis, we need digital forensics. We need digital forensics because with digital forensics, the evidence is collected in a manner that preserves the integrity and authenticity of the evidence. This paper will predominantly look at privacy concerns in digital forensic investigations of a criminal nature. Although digital forensic investigations are used in the corporate environment, in private investigations, and for security incidents. In digital forensic procedures, there is an indiscriminate acquisition or collection of digital data. This means that when someone's personal device, say for example, a phone is taken for forensic analysis, the data is extracted, and in extracting that information, not only do they extract information that is needed for the investigation, they also extract information that is not needed for the investigation. This affects the privacy of an individual, and it affects the privacy of third parties whose information may be found on the device, although that information is totally unrelated to the investigation. In digital forensic procedures, full disk images are created and analyzed. Data can be collected from personal devices. Say, for example, if the investigation is in respect of fraud that happens in a corporate environment, not only the corporate devices would be taken, but personal devices would be taken in order to draw a clearer picture, or in order to collect evidence that has probative value and can help in the investigation. And in so doing, you'd find that there is always a lot of devices being collected. There is a lot of data amassed. Sometimes the information is collected from servers that are outside the country. Say, for example, now in the case of cloud computing, and the privacy issues in respect of data sovereignty arise. And you'd find that in most cases, more often than not, these privacy issues are not addressed in legislation, as may be seen going forward in this presentation. Another privacy concern is that the data subjects, because a digital forensic investigation collects information and processes it, it is not only an interference as it relates to privacy, there is also an aspect of processing personal data. The data subject is unable to give effect to their rights, which rights may be in some data protection law. Now, since the digital forensics and privacy are on one end of the spectrum, they are competing interests, and there has been scholars who have written journal articles and books postulating or speaking to balancing these interests. Predominantly, the proposed solutions are quite technical. There is not much that is legal, and those solutions are encryption, which in this case gives the user the ability to protect themselves by encrypting their information, such that when it goes for digital forensic investigation, the information is protected. And encryption is identified as an anti-forensics. And although encryption works, it may be broken. And then there's been a proposition for privacy levels to say that when a digital forensic investigation is conducted, there must be a classification of data that is required, and there must be classification of the sensitivity of data as and when is necessary, so that data that is not necessary for the investigation is not included in the investigation. There's also been a proposition for privacy enhancing technologies, which would help which would help in balancing the two interests, and there's also been privacy by design. The concern is that all of these propositions are technical. None of them are legal or regulatory in nature. In Botswana, you'd find provisions on digital forensic investigations in 3 acts of parliament. You have the Electronic Evidence Act and regulations. You have the Cybercrime and Computer-Related Crimes Act, and you have the Intelligence Security Services Act. The Electronic Evidence Act provides for the admissibility of electronic records as evidence in legal proceedings and authentication of electronic records. Unfortunately, this act does not regulate the digital forensics process, or it does not provide a manner in which electronic evidence is to be collected. It does not provide for a manner in which, in collecting electronic evidence, privacy protections can be implemented. We also have the Cybercrime and Computer-Related Crimes Act. It was initially enacted in 2007 and amended in 2018. It substantively and procedurally provides for cybercrime. It is substantive in the sense that it defines what a cybercrime is, and it covers the procedural aspect in the sense that it provides for the process to be employed to investigate cyber crimes and to extract evidence from electronic devices. It empowers a police officer to access, search, and seize electronic devices if they have a reasonable ground to believe that stored data or information would be relevant for purposes of an investigation or the prosecution of an offense. Furthermore, it also empowers a police officer to get real-time recordings, real-time access to information, such as in the case of network forensics. The challenge with this act is that the Cybercrime Act is that a police officer would act on reasonable grounds to believe that certain information may be helpful to the investigation. But this is where it is abused, because in most cases, a police officer, or let's say the state, would be of the view that would collect devices without necessarily ascertaining that the devices are critically important for the investigation at hand. We also have the Intelligence Security and Services Act, which establishes the Intelligence Agency for Botswana. As the same way as the Cybercrime Act, it empowers the Intelligence Agency to seize devices and to put them through forensic analysis. But also in the Act, it does not make any privacy safeguards, except to say that before seizing the device, a court order must be applied for. However, in reality, there are very few instances in which a court order is applied for. Most of the time, the state acts on a reasonable ground or a reasonable suspicion to seize an individual's phone. What to deduce from Botswana's legal framework is that there is abundance of empowering legislation, but no regulation as to the conduct of investigations in a manner that preserves privacy. The conclusion is that this is likely to lead to arbitrary and unlawful interference with the individual's right to privacy, which goes unchecked. Furthermore, the individual does not have the option of exercising their data subject rights in relation to the vast amounts of personal data collected and processed in investigations. For starters, the Data Protection Act is not applicable to the police or the intelligence agency when they carry out their investigations. Therefore, one may not exercise their right to access, one may not exercise any right to objection or any right to be forgotten. And then in respect of privacy, digital forensic investigations would be viewed as justified because they assist in investigations. Therefore, it would be difficult to say that an investigation in itself is unlawful. However, the investigations has an impact on an individual's privacy, and it is that impact that is not provided for adequately in law. Now we go to the African Convention on Cybersecurity and Personal Data Protection, the Malabar Convention. It was adopted in June 2014. Botswana is not a signatory and has not ratified the convention. The convention provides that a written document in electronic form is admissible. in evidence in the same way as a paper-based document, and shall have the same force of law, provided that the person from whom it originates can be duly identified and that it has been made out and retained in a manner that guarantees its integrity. In respect of electronic evidence, it only speaks to the admissibility and does not predominantly deal, it only speaks to the electronic evidence for electronic communications and transactions, and does not deal with digital forensics process. Therefore, if Botswana was to ratify the Malabar Convention, it would not assist in its pursuit to provide adequate safeguards for privacy in relation to digital forensics investigations. There is a need for a legal and regulatory framework for Botswana in respect of digital forensics, already identified. There's already technical protections, and the technical protections can only go so far. For example, the example I had given on encryption, there's a way around it. And then if you speak to the other technical protections such as privacy enhancing technologies, an individual may not know whether the state uses privacy enhancing technologies or not, unless some legislation imposes on the state the duty to use privacy enhancing technologies or not. Therefore, in the same manner that, in the same vein that the state empowers itself to carry out digital forensic investigations, there should be checks and balances. There should be a legal and regulatory framework to remediate or to guard against the abuse of that empowerment that has been given to the state. Already, there has been fears that the intelligence agency in Botswana is intruding into people's privacy by recording their phone calls, wiretapping. There has been concerns that the police and the intelligence agency arbitrarily seize people's mobile phones. And then those devices are kept longer than is necessary, and the individual would not know what evidence on them or what personal information on them has been collected and has not been collected. And there isn't any mechanism through which an individual could ask that their information be deleted, if at all it is not going to be of any assistance to the state. The conclusion is that digital forensic investigations are an important part of our lives in the digital era, and so is our right to privacy. The two concepts are naturally conflicting. There are technical protections to deal with privacy challenges that arise from digital forensics procedures. The legal and regulatory protections are, however, lagging behind in Botswana. The legal and regulatory protections are lagging behind not only in Botswana, but in Africa. So there needs to come up a conversation strictly focused on how an individual can be protected in relation to their privacy when it comes to digital forensic investigations. It may be investigations in respect of criminal allegations. It may be investigations in respect of the workplace, because in the workplace, the digital forensic investigations are carried out there for disciplinary offenses and for other investigations such as fraud. But there isn't any checks and balances. There isn't any limitations for the employers, except to say that yes, they may be bound by the constitution, and they may be a right to privacy at common law, but the rights do not sufficiently deal with matters that relate to personal data. Hence, the enactment of legislation such as the Data Protection Act to give effect to the right of privacy as it relates to people's data. That would be all for my presentation. I will take questions for now.
Okay, thank you very much, Ms. Modise, for the very interesting presentation. Uh, it's an interesting presentation in that it goes into the sectoral aspect of data protection. Before now, we've been hearing more presentations on the general aspect of seeing how the general framework protects individual personal information. You've given us the perspective of Botswana, the development of the right to privacy and data protection. You've told us that you have a privacy and data protection legislation in place, which is yet to be enforced, if I get you correctly. You've also talked about the difficulty of balancing law enforcement in terms of criminal investigations and data protection. You've also, or you furthermore made a very important recommendation that there is a need for legal and regulatory framework which regulate aspects of digital forensics particularly, or digital forensics particularly. Thank you very much for that. I have a comment, and I have there's a comment on the platform, and there is a question. The comment is from Prof. Sutherland, and he has the view that the enormous volumes of data on smartphone present serious problems. He's suggesting that you need training for police, advocates, and judges. You need to discover the phone data to defend or to defense lawyers. You need to discover the phone data to defense of lawyers. There's also another interesting question, which probably, if time permits, I would like other presenters from other jurisdictions to attempt. But Ms. Modise, the question is particularly directed at you. The question is that what is Botswana doing to ensure the judiciary understands the electronic evidence being presented so that cases are not thrown out because of lack of technical understanding? So Ms. Modise, you just give us a brief perspective to this question.
Thank you for the question. I'm not aware of what is being done to ensure that the judiciary understands electronic evidence, but there has been one decided case in which electronic evidence was used. In that case, the judge confirmed that electronic evidence is admissible, and that to admit electronic evidence, it must be authentic. Its integrity must not be questionable. So for now, that's where we are, but there are many cases in which electronic evidence is presented as evidence, but not electronically, in paper form, say an email printout. And usually the other party, the opposing party, never raises an objection. So maybe the training should not start with the judges, but the training should start with the legal practitioners, so that they are able to know the necessary objections to raise when electronic evidence is presented in paper form, and in paper form we are unable to ascertain its authenticity.
Okay, thank you very much, Ms. Modise. I cannot find any other question, but I would just like you to just briefly comment on, at least you've made us understand the context of digital forensics and how it constitutes a problem to privacy and data protection generally. In your view, what recommendations can you make with regards to the appropriate instruments to balance these potential conflicts? Will you advocate that the data protection law be more technological neutral? Do you advocate that it should be elaborate enough to cover items like digital forensic, or we should have a sectoral law, a sectoral data protection law on digital forensic? I hope you understand the context of my question.
I understand the context of your question. I think a sectoral law may work, but the sectoral law may focus on law enforcement. But I think ideally, say a regulation to the Data Protection Act or an act on its own that makes provision generally for how digital forensic investigations are to be conducted, and with particular focus on balancing the two competing interests. To say, if you are going to carry out a digital forensic analysis on a device and outline the various types of forensic investigations that could be done, this is what you have to do. In the same manner, digital forensic investigations follow a very stipulated and critical step, then one ought to also take into consideration privacy in the same manner that you take into consideration integrity and chain of custody.
Okay. Thank you very much for this incisive review, Ms. Modise. I think if time permits, we're going to come back to you. Let us have a broader conversation on some of the general questions that have been asked. Thank you very much for your contribution. Now, we're going straight to the next, or the final presentation for today, and it is by Mr. Samuel Matsiko. I hope I pronounced it correctly. Mr. Matsiko is going to make a presentation on European contractors and pension fund administrators in Uganda, independent or joint controllership. Mr. Matsiko is a researcher based in Amsterdam. He has taught at the Ugandan Christian University. He also volunteers with Bits of Freedom and Independent Dutch Digital Rights Foundation. Mr. Matsiko holds an LLM from Humboldt University and the University of Western Cape. So Mr. Matsiko will give you 15 minutes to make your presentation before taking contributions from the participants. Thank you very much. Over to you, Mr. Matsiko.
Okay. Thank you. Thank you, Lukman. And can everyone see the screen?
Yes, we can see it. I think you can go on.
Okay. Thank you to the organizers and the participants for taking their time. Well, I'll go straight to the paper. My paper is titled European Contractors and Pension Fund Administrators in Uganda, Independent or Joint Controllership. The paper will be divided in 3 parts. I'll give a background and the context, and then I'll discuss the substantive issues on joint controllership, and then I'll relate it to this particular case, and I'll conclude. But without wasting time, let's go to the background and context. Now, last year, I think it was in June, a Luxembourg-based contractor was awarded a contract to automate and to automate the pension fund administration system in Uganda. And part of that process, when the automation and implementation of the administration, the pension administration system started, a Ugandan national, and a resident in the European Union started receiving unencrypted emails containing personal data of other data subjects of the pension fund administrator. Now, what the Ugandan did, he was currently a resident in the European Union. He was concerned that the unencrypted emails or unencrypted personal data of other data subjects in his personal email were not only putting other data subjects' personal data at risk, but also putting his personal data at risk. So he decided to exercise his right to access, and he submitted a data subject request pursuant to Article 15 of the GDPR, or what we call the European General Data Protection Regulation. Now, the Luxembourg controller replied to this Ugandan and stated that 1, they do not process personal data, and that 2, that should they be found to be processing personal data, they could not be classified as a data controller, and that 3, they were only providing technical means and therefore could not reply to his data subject request. At that time, the Ugandan was not convinced by the reply from Luxembourg controller, And his argument is that within GDPR, the Luxembourg controller is actually a joint controller within the definitions of Article 26 and Recital 79 of the European Union, within the definitions of GDPR. And furthermore, the recent decisions of the European Court of Justice, in particular a case called Fashion ID, that has extensively discussed the issue of joint controllership. And so the Ugandan currently is seeking redress within the National Data Protection Commission and plans to further seek the opinion of the European Court of Justice on whether the Luxembourg controller and the pension fund administrator in Uganda are joint controllers. Now, it's very important to understand that there is an extensive body of law on the issue of controllership. Who controls the data, especially the issue of joint controllership. And the body of law in Europe is very extensive, from GDPR to Article 29 to, we have a directive called 1725, which we call the EDBS guidelines. And recently, last month, the European Data Protection Board published guidelines on joint controllership. We also have the National Data Protection Act of Uganda that provides the issue of joint controllership. But because of time, I'll go straight to the subject. Now, there's also relevant case law on who is a joint controller, and some of these leading cases are from the European Court of Justice, Fashion ID, and the Holstein case. But let's go to who is a controller. Now, it's very important when you're talking of data protection to understand who is the controller, because the issues of who is a controller are very important in terms of liabilities, obligations, and responsibility. So the law says that a controller means the natural or legal person or public authority, agency, or other body which alone or jointly with others determines the purposes and means of processing personal data. So from that definition, you can see that it envisages multiple actors, where it says alone or jointly with others determines the purposes and means of processing personal data. Now, it has three elements. You either process the personal data alone or jointly, you determine the purposes and the means, and at times determining the purposes and the means is dependent on the factual circumstances and not a formality. You don't need to have a contract to be labeled as a controller. But when does a situation of joint controllership occur? This is what is very important, because most entities do not want to be labeled as joint controllers. But when does a situation of joint controllership occur? Now, we have two scenarios, and one of them is an opinion from 2020 from Article 29, the working group. It's a situation of a travel agency. You want to take out a travel package from a travel agency. It processes your personal data, gives it to the airline. It also gives it to the hotel, and they book accommodation for you. Now, those different individuals engaged in the processing of the personal data, the travel agency, the airline, and the hotel are different controllers processing the same set of personal data. In that situation, there is no joint controllership. However, there is a situation whereby if the travel agency and the airline put up a shared online platform and they begin sharing this personal data, probably for commercial purposes and integrated marketing, if they put up a platform for convenience to allow them to share this personal data as one, then they could be labeled as a joint controller. Now, Article 26 of the GDPR clearly says that where two or more controllers jointly determine the purposes and the means of processing, they shall be joint controllers. And we have a body of case law, for example, Fashion ID. This is a case that is at the European Court of Justice. It was a case to do with website operators and social networks like Facebook. And the court was of the view that once there is a unity of purpose between the website operator and the social network, then the issue of joint controllership does occur. Now, in our particular case, the Luxembourg controller argued that, one, it did not have the personal data of the Ugandan. Now, it's very important to ask yourself, can a situation of joint controllership occur without access to personal data? And the law is very clear in Europe because the EDBS guidelines clearly show that an entity does not need to have access to personal data to be considered a controller. There is also a German case that went to the European Court of Justice. It's called the Holstein case, where the European Court of Justice was of the view that mere access to anonymized data brings about a situation of joint controllership. Now, what's important is if the parties determined the purposes and the means of processing. Who initiated the processing and why did they initiate the processing? Then a situation of joint controllership does occur. And in this particular case, the Luxembourg controller argued that they did not have access to personal data. The Ugandan says, no, look here, European law, whether you have or you do not have personal data, a situation of joint controllership can occur by mere having access to anonymized data. Let me give you an example. For example, the Center for Human Rights has a website, but it has social plugins, for example, Facebook and Twitter, all embedded in its website. If I click on the social plugin of Facebook, Facebook may not have my personal data that I've gotten from the website of Center for Human Rights, but they could have some analytics knowing that this gentleman in Amsterdam visited the website on this. They could have some usage, some data, how I used the website. And so mere access to anonymized data does bring about a situation of joint controllership. Now, what are the obligations of the controller? One of the most important obligations of a joint controller is the issue of data subjects' rights, the right to access, and this is also clearly established in Article 26 of GDPR that provides for joint controllership, and it says that a data subject may have the right to access to either of the joint controllers. So in this aspect, the Ugandan chose to submit his subject access request to the Luxembourg controller within the definition provided in Article 26. And even if there is a contract or a formality between the joint controllers, the law is very clear, especially in GDPR, that irrespective of the terms of the arrangement, the data subject may exercise his or her rights in respect of and against each of the controllers. Now, just to wrap up, is the Luxembourg contractor a controller? My answer is yes. One, for you to be a controller, you need to be a legal person. In this case, the Luxembourg controller is a legally incorporated company in 1996. You need to determine the purposes and the means. In this instant, the Luxembourg controller, jointly with the pension fund administrator in Uganda, set up a shared platform where they determine the purposes and the means, which were automation of the pension system. Two, the Luxembourg controller had a privacy policy that states on which kind of data they collect. And it was very clear that they process personal data, that they do all these kind of things. But because of time, we need to understand, is a Luxembourg contractor a joint controller? The Luxembourg contractor, in a nutshell, is a joint controller by provision of a shared infrastructure. Once you provide a shared infrastructure or a shared platform between Mr. A and Mr. B, then a situation of joint controllership occurs. But what is important is that both the parties determine the purposes and the means of the processing. So at the end of the day, the test is the purposes and the means, where there are multiple actors. Now, in conclusion, this is rather new, especially with GDPR and the decisions of the European Court of Justice. There is a discussion that European law does not apply within African jurisdiction. I think that discussion is misguided because European law is extraterritorial. On paper, it does not apply, but in practice, it is extraterritorial, especially with data protection. And in these particular circumstances, we are yet to see what will happen from the National Data Protection Commission in Luxembourg. And also, if the matter is to go further to the European Court of Justice, then that opinion will help us build jurisprudence within the African context on how far the long arm of GDPR applies within the African jurisdictions. So thank you, Lukman, and I hope I was able to use the 15 minutes, and now I'm open for some questions.
Okay, thank you very much, Mr. Masiko, for the very incisive discussion and for highlighting a very salient aspect of data protection law. This shows that the conversation is not only ongoing, but the conversation is expanding in terms of data protection law. I appreciate the Ugandan perspective because most African countries, you find out that what happens in most African countries is that in many circumstances, because of the insufficient technological capacities and capabilities around African countries, you find out that in many circumstances, many of them have their personal information being processed in other countries, in Western countries, and so on. So the issue of joint controllership, or the issue of who is a data processor or who is a data controller, is a very interesting issue, which I think should be addressed, or which I think should be critically looked at. Unfortunately, data protection laws do not really give so much clarity on the full meaning of a data controller. It merely says that it is the person who decides or who determines the way and manner in which personal information should be processed. But a lot of other questions will be asked. For example, where there's a situation of a subsidiary in a country, sometimes local legislation or domestic legislation do require that subsidiaries be incorporated under the necessary domestic law. So in that particular regard, since those subsidiaries are termed to be separate legal entities and so on, will you say that they are independent controllers or joint controllers? So thank you very much, Mr. Masiko, again for this presentation. I think I can see a question for you here. Let me just fetch it. The question is that do you believe that the European Union law is extraterritorial in nature? And is it not against African countries' sovereignty? I think this one is a more general question. So probably you can just talk about this before we try to see if there are other questions. That's with regards to the extraterritorial nature of European Union's law and the long arm, as data protection activists or data protection scholars would say, the long arm of the law. Do we fold our arms in Africa, since we're looking for creative ways or innovative ways? Do we fold our arms in Africa to that long reach or the impact such kind of legislation or such kind of instruments has on the sovereignty of nations? So I would just like you to briefly comment on this before we seek other questions or contributions from the participants. So, thank you very much. Over to you, Mr. Masiko.
Thank you, Lukman, for that. I think I'll not discuss so much about sovereignty. I'll just discuss a bit of the extraterritoriality. Yes, I think because as Africa, we lack the technical means. The moment we lack the technical means, the issue of European data protection rules applying, kind of raises, and that conversation is very important. And at times, within the African context, because we want to be independent, we want a decolonized kind of agenda, an Afrocentric kind of data protection regime, we kind of brush off these issues. But the truth of the matter, the mere fact that most of our websites and our databases are hosted in the European data centers in Frankfurt and in other European capitals, then the issue of the extraterritoriality applies, because what we need to understand that, one, EU law deals with the person who is on EU territory. Now you find that there are many Africans who actually live in the European Union, but they have operations in Africa, they have transactions in Africa, they have phone numbers in Africa. So I do believe that EU law on paper is supposed to be within the territory, but if you get a torch and look deep inside it and open it, or you lift the veil, it is actually more universal than we think, and it has extraterritorial jurisdiction. Yeah.
Okay. Thank you very much. I can see you need to put off your shared screen. You can just do that quickly. So basically, thank you very much for the incisive conversation, or for the incisive presentation on this aspect of extraterritoriality. I cannot really find any question for you, but since we have slightly about 15 minutes, I would like to go back to Prof. Sutherland, and I would like you to revisit the questions that you were trying to attend, that you were answering before you suddenly went off. Then in concluding, I would like you to briefly address the issue of extraterritoriality, because that's one common trend I'm seeing, and I've seen a couple of reactions with regards to the extraterritoriality of the European Union law, of the EU law, with regards to its impact in Africa. So briefly, I would like you to just briefly comment on its impact on sovereignty of African states, since it's something we jealously guard in Africa. So you can just comment on this in about 2-3 minutes, so that we'll move on to other commentators. Thank you very much.
I think Samuel kind of gave the game away.
Yes.
By the question of where the data is stored. If inevitably, if people host data in the United States, or put data into Facebook, or put onto one of the Chinese systems, then it's going to go to that other jurisdiction. And so what Samuel was describing was a data which was in one way or another being held or processed in a European country. And the challenge is to come up with some kind of regime. Now, the catch, if you take the South African example, you might naively imagine quite a lot of data from other countries coming into South Africa. But the legal framework for that is very thin. So the question of sovereignty is tricky in a world where you don't know where the data is going to be held or moved to. You often don't look at where. So those of you who are familiar with GDPR will know that a lot of the European data goes through the Republic of Ireland, and its data protection commissioner is responsible for things, which is a slightly convoluted way of doing things. But we are in a world where very large amounts of data are shipped around very readily, and trying to work out whose jurisdiction it is very tricky. And the only reason in some case, in the case the data comes to Luxembourg, is probably because you can't do it in Uganda. What happens if you've got data in Uganda that goes to South Africa? Do you have any legal framework for that? And that's where things like not having the convention in place makes life very difficult. You need to have the robust domestic. Then you end up with arguments between different regimes. That's why you end up with the argument between the European Union and the United States. But always remembering that the part of the argument in the US is that by less data protection regulation, it encourages innovation. But the US is having a domestic argument. Should it move closer towards the Californian model, or should, you know, what if you've written a federal law in the US, is it a lot of protection, or is it a minimal level of protection? So, you know, these sovereignty arguments are very difficult to deal with. That's why the European Union created the framework, so that you could move data around and it would still be protected. That's why originally the OECD recommendation, the Council of Europe Convention, the Data Protection Directive, and now the regulation.
Thank you very much, Prof. Dr. Ajibo, are you still here? Dr. Ajibo? Collins? Okay. Pending when Collins return, I would like.
I'm still around, please.
Okay. So please, can you just sorry, Collins. So can you just briefly just speak to the issues of extraterritoriality as it impacts on African countries and the GDPR, and slightly or briefly just talk about the issues of enforcement, because in your data protection, in your presentation, you mentioned the issue of the challenge of enforcement. So very briefly in concluding, just speak to those issues so that we can move on. Thank you.
It's all right. With regard to extraterritoriality of EU data regulation, I think that it only applies if the data subject or the processor or whatever, if there is let me put it this way, if there is a connection between the processing and the EU jurisdiction. I do not think, with regard to my own particular presentation, that if the processing, the data processor or the data controller, and data controller are based in Nigeria and they are incorporated under the Nigerian law, and the data subjects are also Nigerian citizens domiciled in Nigeria, I do not think the issue of extraterritoriality should be a problem to Nigeria. It will only apply when there is a connection between processing in Nigeria and the EU jurisdiction. That, having said that, with regard to issue of enforcement, maybe with regard to you might be conversant with the situation in Nigeria, but with regard to non-Nigerian nationals, the issue of enforcement and compliance are a very critical issue, in the sense that when a government agency or powerful individuals are involved in breach or breaches, it may be difficult to enforce compliance, in the sense that it could be that the victim or victims would they have the capacity to go to court, and probably they will get a favorable ruling. And obviously, the next thing should be enforcement. But if it were a government agency and heavily supported by maybe the presidency, if you like, then it might be very difficult to enforce the rulings, whether from court or administrative rulings. And equally, powerful politicians with powerful connections, if you like, and probably connected to the presidency too, might not be, even if their company or individually they breach data in Nigeria, it will be difficult to enforce it except if they are doing so on good faith. So this is the problem, as I mentioned before, regarding enforcement and compliances in Nigeria. So it remains to be seen, as I concluded, how this will be, tackled and sorted out. So let me be optimistic that it will not happen, but deep inside my mind, I know in one way or another, this issue of compliance will keep on being a burning issue in the future.
Thank you very much, Collins, for this incisive presentation, for this incisive response. I would like to move on to Ms. Modise. I have a question for you, which I've tried to caption in a more elaborate format. Ms. Modise, are you there? Ms. Modise?
Yes, I am here.
Okay, thank you. So there's a question with regards to the issue of lack of sufficient understanding by judges of the courts. You know, the way data protection, as you've mentioned, or as other presenters have mentioned, the way data protection operates, it operates in such a manner that whenever the Data Protection Authority is called upon to give a decision, the Data Protection Authority will be asked to give a decision, and if that decision is given, an individual, a data subject, is also given that right of appeal, or sometimes even the data controller is giving up that right of appeal to courts. So there's the challenge with regards to the understanding or the level of appreciation of judges of such issue, because it's not just for the Data Protection Authority to be able to sufficiently understand these issues. We also have to have judges that sufficiently understand issues. So please, what do you have, or what can you say with regards to the issue of judges appreciating data protection issues for us to carry on with the conversation, or for us to carry on with adequate data protection? Thank you very much, Ms. Modise.
Okay, thank you very much. I think just like any other new area of law, judges would need training to be able to appreciate the issues around a certain matter. For example, we had an issue before the High Court in respect of the official contact tracing application. It had a vulnerability which was exposing personal data of users over the internet. And we sought to make a vulnerability disclosure to the government. The vulnerability was not fixed until a month later, when we sought to make an urgent application to interdict the availability of the app until the vulnerabilities are solved. And in making the urgent application, when we appeared before the judge didn't seem to appreciate what the issue is. So yes, there needs to be training, and apart from training, I think there needs to be a conversation ongoing, and there needs to be a regulator. That conversation can easily be made by the regulator.
Okay. Yes. Thank you very much, Ms. Masiko, for Ms. Modise, for this incisive response. I would like to come to Mr. Masiko finally, because we don't have so much time. I think we'll have about 5 more minutes to wrap up. I just want you to briefly react to the issue of judges, the capacity of judges with regards to, from the perspective of Uganda, with regards to data protection issues. Please, can you just do this for us in 1 minute so that we can quickly close this conversation? Thank you so much.
Thank you, Lukman, for that. But the issue of judges is very important, and currently in Uganda, in another area I've been researching on, it's an issue I've raised because currently there's a lot of unregulated processing happening in Uganda, especially within the judiciary and the use of the new electronic filing system. But just to conclude, Europe has moved far away. For example, if you look at all judiciaries, they have what they call a data supervisory judge. You'll find that there's a data supervisory judge. I think the EU has a project called the Inform Project that is doing a lot of awareness. I think the judiciary, all we need is some level of awareness, and we'll move forward. Yeah.
Thank you very much for the incisive session. We've had 4 incisive presentations from various jurisdictions trying to give us a picture of where we are in terms of privacy and data protection in Africa. We have seen from the presentations that, yes, we are making significant efforts in Africa, or we are making efforts. I would not really say significant efforts, but at least we are making an effort in terms of having data protection legislation, data protection instruments. But the question still remains the challenge of sufficient or quality enforcement of these instruments. We have also seen that we are now having a situation of more intrusive privacy technologies. Somebody have spoken about digital forensic, or Ms. Modise has spoken about digital forensic. Dr. Ajibo has raised quite interesting issues with regards to emerging technologies challenging data protection in Africa, which we really need to carefully look at. We have seen that there are numerous challenges with regards to privacy and data protection, and we really need to keep the conversation ongoing, issues of extraterritoriality and so on, issues of raising awareness, issues of capacity building and so on. So that's basically what these country studies have shown us with regards to privacy and data protection in Africa. I would like to thank all the presenters for the incisive presentation, Prof. Sutherland, Dr. Ajibo, Ms. Modise, and Mr. Masiko. Thank you very much for the incisive presentation and for the lively session and for the very intelligent means of responding to questions. On behalf of the Center for Human Rights and its organizing partners, I thank you very much for this, for the robust participation. I thank the members, or I thank the participants. It was really an engaging, an interesting session. So on my part, thank you very much. Over to you, Ms. Dube.
Thank you very much, Lukman, for facilitating the session on the country studies. I don't want to say much on the session. It was very informative. Thank you to the presenters. Thank you to the participants. Tomorrow we will continue with the conversation on privacy and data protection in Africa. Tomorrow at 11 o'clock South African time. Our session will be on data protection, cybersecurity, law enforcement. I know we have already touched some of the issues in some of the presentations, but tomorrow we'll get into detail again about that issue. So we'll be looking at data protection, cybersecurity, law enforcement, and national security. That will be the focus, and Prof. Ewan Sutherland is going to facilitate that session. It will be at 11 o'clock South African time. The meeting details, we will still send them an hour before the session, but they are the same details that we've been using since yesterday. We'll use the same details. So in the afternoon session, my afternoon, the session will be on privacy, data protection, and artificial intelligence, and we'll have 4 presenters during that session. So thank you very much, and thank you for your participation. We appreciate your support. Thank you.